Hello viewer and welcome to the platform, a program that will educate Kenyans on the freedoms and constitutional rights. It will give them a sense of the nature of the law and equip them with the knowledge on how to solve domestic, civil and criminal matters legally. All this will be achieved through a platform where law students from Kenyan universities will be at the center stage to engage a panel that will be made up of experts of the law from different institutions in both public, private and civil society. Today, our topic of discussion shall be the gender role vis-a-vis affirmative action as established by the 2010 Constitution. Our panelists of the day, I'm going to introduce them from my immediate right. We have Sindano Gakuru, who's an advocate of the High Court of Kenya. We have Atsango Chisoni, the Executive Director, Kenyan Human Rights Commission. We have Boniface Oduor, a fourth-year law student at the University of Nairobi and current chairman of the Legal Aid Initiative at the University of Nairobi. With us, with the audience, we shall have students of law from University of Nairobi and Kenyatta University. Ladies and gentlemen, welcome. Affirmative action can be described as the positive discrimination of one group of society with a view of enhancing their livelihood in an area of education, employment, or business with regards to past injustices. The Constitution of Kenya 2010 provides a constitutional anchoring for the same. Many analysts and citizens at large have said that affirmative action as such is foreign to this country. My question perhaps to Atsango will be, is this largely true? In your opinion, is it foreign?
Actually, it's not. That's exactly how Kenyan men got into Kenya's parliament. If you remember, this country had a racial segregation system. It used to be called Calabar. And if you talk to older people, they'll tell you that there are places in Nairobi where people of African descent could not live. There were schools that you couldn't send your children to. African people were not allowed to own businesses, only Asian people were. European people could engage in anything. African people were restricted in terms of what they could own, where they could live, how they could live in terms of their political activity. So when you look at the parliament that Kenya had before independence, which was the Legislative Council, and sometimes, for those of you who like to talk to your grandparents, and if you're lucky enough to have great-grandparents who are alive, what they refer to as the LegCo, you will know that initially it was only Europeans and Asians, and people who were what were known as colored people, basically, were allowed to sit in the LegCo. And even for them, there was a quota, i.e. there was a number of people who were not of European descent who could sit in the LegCo. And finally, the rules for the LegCo were changed, and an African man was allowed in. And then a few more African people, all of whom were men, were allowed in. And then eventually by 1962, because it is that LegCo that went to Lancaster House and wrote the old constitution, the members of the LegCo went to Lancaster House to write the constitution, and in that LegCo there was one woman. She was called Priscilla Bwao. And she was not allowed to speak at Lancaster House, but she presented something called the Memorandum of the African Woman, which was the demands made by African women about the Constitution. Now, I just want to explain that one historical fact that many people don't know. Because of Kenya's history, one of the people that was involved in the writing of Kenya's old Constitution is the late Justice Thurgood Marshall of the United States Supreme Court, who had been the person acting on behalf of the NAACP on the issue of Brown versus Board of Education, which, as you know, is the case where the education system in the United States, which was also racially segregated, got desegregated. And therefore, affirmative action was provided for in the old Kenyan Constitution under Section 82(4)(d), whereby if you had a group that had been discriminated against on any of the prohibited grounds, and there are several prohibited grounds in 82, including sex, but sex was included later. in 97 into that article, you will see that those people who come from those groups are entitled to affirmative action measures.
Thank you. Looking at the 2010 Constitution, perhaps what comes into mind is the issue of gender, because you're talking about not more than 2/3 should be of the same gender. Currently, the nation is faced with a quagmire on how to implement the same. In your view, Sindano Gakuru, what are some of the ways in which the gender rule can actually be implemented?
First of all, I wouldn't call it a quagmire, because where we have come from, having the name, the title gender, being a topic of discussion is just shows how far we've gone, and having it embedded in our constitution means that the hard work has been done. It only now remains to adopt an approach which guarantees the constitutional obligations that have been that we accepted once we ratified the new constitution. And such is what is happening in the August House, in Parliament. They are grappling between how do we ensure that gender representation meets the constitutional threshold. There are a number of approaches that many other countries have taken, but which doesn't guarantee, because you're dealing with an open policy where it is fast through the finish line, more or less approach to elections. But it is an attempt. There is you could call proven paths that have been taken. There is one that requires political parties to shortlist members of parliament or nominees or party candidates who should the number of women and the number of men is determined. That's a shortlist, and that is what the Labour Party does in the UK. There is the other approach, which seeks proportional representation, where through either an act of parliament or through the constitution, a number of seats are specified for with gender representation, gender or minority group representation. An example is Uganda, where you have a number of seats reserved for women, and that is what you can call a specialized constituency. And then there's a blend of both. Of course, there isn't any fast and hard rule, because you're dealing with the demand, the rules of competition, where if in any election it is going to be difficult to dictate who shall win where. And this also posed a problem in the UK, for example, where certain constituencies refused to follow the party the policy of what you call all women's shortlist. So a brief history of where we have reached. I'm sure Madam Ms. Chisoni is better placed than I am, giving the small history as to what forces were grappling, were jostling for the provisions of the constitution as it stands. Is that there was that democratic space that we wrestled, and that's why we have the Political Parties Act. That would be one of the means of guaranteeing representation. If you look at the demographics, we about 52% of Kenyans, of the Kenyan population, are female. Given the chance, then you could say that, depending on where you come from, is that a lady candidate may stand a better chance than a male candidate.
Okay. Perhaps an interesting point has been raised there with regards to party lists, because the whole essence of affirmative action is to try and place both genders at a near equal or equal position. Some of the arguments that have been posited is by nominating somebody to parliament, you're basically not providing that deficit. You're actually making it bigger because there's the option of the person being elected. I'll actually take it to Boniface. Nomination vis-a-vis election. What is the way forward in terms of solving the gender disparity that has existed in this country?
Thank you very much, Mr. Jimakach. I first of all like to be, I'm very much privileged to share a podium with my very learned colleagues. I'm a fourth-year student, and I actually am aiming to be where they are right now. But looking at that issue of election vis-a-vis nomination, we should actually realize, that we are in somehow a patriarchal society as it is right now. That is my view. And therefore, where such matters cannot be attained via election, then we should have a scenario where nomination should actually be a part to cure that particular inadequacy in terms of elections. And therefore, taking the view of nomination, where the two-thirds majority or the two-thirds rule has not been met, that we should go the nomination way, since that can be a very nice way of solving the various inadequacies posed by the Constitution. In light of our society as it is right now, there is the issue of patriarchal society. People are not. There are some societies whose culture is they cannot have a woman as their leader, and therefore nomination is rather a very good way of solving such kind of inadequacies. And that maybe is my take. That is my view.
Atsango, if I can drop you in at this point. One of the challenges with nomination that people are talking about is that once a parliament has been formed, people have been elected into parliament. We have a parliament that is not meeting the two-thirds gender rule. You will have to nominate people using the party-less system. Mm-hmm. What then happens is that we'll have what is being referred to as a bloated government, a bloated legislature. Mm-hmm. The cost of this, people are saying, is too much. The question is the cost too much compared to the cost of trying to bring a more gender-balanced society?
Thank you very much. I think there's one correction I'd like to make, that what is actually being proposed and in the bill, in the constitutional amendment bill, which follows the lines of what is in Article 177 of our Constitution currently in respect of the Constituent Assembly, is actually not nominated seats. There are only 12 nominated seats, elective seats in our current Constitution, and those are in the National Assembly, and they were introduced by parliamentarians. Party lists are not nominated seats. They are part of what Mr. Sindano was referring to. They are part of what is known as a proportional representation electoral system. So in a and this is the distinction, when you have proportional representation systems, the list of people who will be nominated by the party is known before the elections take place. These people actually campaign for the parties. And this is the electoral system in South Africa, in Scandinavia, all of which are countries where you have very high numbers of women in their parliaments, but you also see other forms of diversity. So just to be very clear that we have managed to get ourselves muddled in terms of our public discourse on this issue. Now, in terms of the bloated legislature, and would we consider it to be bloating the legislature if we decided that a part of Kenya, let us say we were talking about a geographical constituency, because women constitute 52% of the population, so they're actually majority of the population. If we had decided, if let us say by some quirk of nature we had an ethnic community in this country that had 52% of the population, and less than that, than